Hey, I'm John Strohmeyer with Strohmeyer Law. We're back with another live stream answering your questions about trusts, estates, and taxes. Remember, I'm John Strohmeyer with Strohmeyer Law, where I'm an attorney focused on these issues. I'm a lawyer, I am not your lawyer. So, with that in mind, let's get to our first question. So, what is a spendthrift trust? Spendthrift trusts come up a lot, and it's a tool we actually use quite a bit in estate planning. This is a trust that basically protects or a beneficiary from using the assets and basically spending them everywhere. Now, I get confused on the actual definition of spendthrift. I think it really means look, they spend all of their stuff, they are not thrifty. But the point is, you're protecting the beneficiary from having all the assets in the trust dissipated. Now, when we use these as part of estate planning, well, we want to embed these protections in so that the beneficiary is getting the protection of the trust from predators, creditors, and future ex spouses. So, thinking about things like if somebody comes along and wants to take advantage of them, those could be the predators. They're trying to get in at the money. You may have a trustee in place who can, protect the beneficiary from themselves. Creditors, well, if they're in a situation where they may be subject to liability, assets inside of a spendthrift trust will be protected from those creditors' claims. Finally, future ex-spouses, if the assets are in a trust, it's a very good way of setting out these assets here in Texas. They're not community property. They're not separate property. They're assets that belong in the trust. The trustee has legal title to them. The beneficiary has no ability to call it their own property. It belongs to the trust. And because it belongs to that trustee, it's not separate or community property. So in a divorce, it's not even on the table uh, to be divided between the spouses. It belongs to the trustee, even if that trustee is also the beneficiary. And that's one of the things that we think about with these spendthrift trusts. Again, you're setting it up, you're putting protections in place to protect the beneficiary from future threats, even though it originally came from something of we're going to protect the beneficiary from just wasting the money. Next question. Is company owned or Keyman life insurance subject to tax? If so, what kind? Now, this is going to, we're going to talk about two different types of tax: estate and gift tax. Do we think about it there? What about income tax? Now, when you have life insurance owned by a company, there are additional rules. You're going to have to sign certain waivers and consents, even if it's a single owner, like my law firm, I'm the only owner. If I get life insurance on myself, I still have to sign waivers consenting to the life insurance being taken out on me. That's a compliance issue because what it'll do is it will unwind the benefit of having that life insurance be received income tax free. This is one of the big things that life insurance generally is received free of income tax. But if you don't jump through the hoops for Keyman insurance, it can be totally subject to income tax when it's received. And this is one of the things we want to do. Like, the company is buying this insurance because if one of those key people passes, you're getting income to supplement either revenue they would have brought in, go out, hire somebody new, pay them as a signing bonus, or buy out a spouse for their interest in the company. All of those are good reasons why, and you don't want to pay extra income tax on it if you don't have to. When it comes to estate tax, it may be subject to estate tax, and it's going to depend on how it is structured and who's getting that payment. Remember that even though life insurance generally is received without having to pay income tax on it, the life insurance proceeds can be subject to estate tax in the deceased's estate. And again, it's because they have the ability to control who gets it. So, life insurance, it's a great tool. It is something that will be received generally free of income tax. For Keyman policies, you want to make sure that you've signed all the proper paperwork and you've reported that ownership to the IRS. We've got another video on that. We'll put a link to make sure you can see that. For estate tax purposes, it'll depend on whether or not it is subject to estate tax. So it's a good tool. Just make sure you've checked your tax boxes on it. Next question. Is your IRA protected from a lawsuit in Texas? What about creditors? So This is really a way of asking the same question twice. The IRA itself isn't going to get sued unless, Fidelity or whoever the custodian of that account is has done something wrong. So the IRA is not really liable in that sense. But what we're getting at is, if somebody sues you, can a creditor in Texas seize your asset? So the process would be, you have potentially done something wrong. Somebody sues you. Not only do they win the lawsuit, they also win damages against you. Well, once they do that, what assets can they seize? Generally, tax advantaged accounts like 401ks, IRAs, and even things like life insurance are going to be protected from future creditor claims. Why? Well, Texas likes to protect debtors. We're a debtor friendly state. So putting those assets beyond the reach of a creditor helps ensure that you get to keep your property. You also get to keep your homestead almost regardless of value. There are some limitations on that, as well as car for every driver. There's a lot of protection for debtors. But getting back to the IRA, can a creditor seize it? Generally, no. There are some rules about, well, if you jam a bunch of money after you know that you've been sued into that IRA, potentially under a fraudulent transfer, they can get it back. But for the most part, assets in an IRA are going to be protected from creditors. Remember to talk to your specific attorney about your specific circumstances, but generally speaking, no, this is not going to be subject to a creditor's claim. Next question. I won a wrongful termination lawsuit. Is this subject to tax? So, when we think about taxes, I'm always going to think about two different types of taxes: income tax and estate tax. So, when we think about income tax, when you win a wrongful termination suit, essentially what you're getting is a simulation of the income you would have received. What we're not talking about is personal injury. Like you're not being compensated for an injury to your body. When it's a wrongful termination, generally, yes, this is going to be subject to income tax. It's simulating those wages you would have received. When it comes to estate tax, well, when you receive it, no, there's no tax. You're receiving it then. If you die and it's too much money, if it's over $12.92 million in 2023 or over what we think will be about 6.8 million in 2026 when the exemption drops, that can potentially be subject to estate tax if you still have it. So when you think about these settlements, remember part of part of what you're thinking about is, how will that be taxed? Is if this is going to be fully subject to income tax, there's not going to be a whole lot you're going to be able to do about it, but at least you can, make sure you don't overspend that check before you get it. Next question. What kind of expenses can an executor of an estate take in Texas? Well, generally speaking, the executor or an administrator of the estate, the terms are basically the same. They are allowed to spend normal amounts to maintain and preserve the assets of the estate. So when they think about this, it's really what's appropriate. So if there's a house in the estate, they're going to want to make sure they're paying taxes, keeping the insurance up to date, keeping the bills on and going so that the house doesn't fall apart. They don't necessarily need to make improvements to the house, but they should keep things in good working order. Beyond that, whatever they're going to need to do to sell things, so if they've got to arrange for the house to be cleaned, if they need to have junk hauled off, trash pulled out, things like that, those are the sorts of normal things they'll be paying for. What else? Tax returns, paying for attorneys, anybody else to help them get through the process. That's going to be a normal estate expense for the executor. Now, whether or not they've got other things, you're going to want to look and see, well, is this appropriate? Circumstances, situations change. So, what may be appropriate in one estate may not be appropriate in another state. Remember to talk to your attorney about that. Next question. How does an executor physically pay off the estate's bills and debt? Do they have their own checking account? And yes, what you would want as an executor or an administrator of an estate is to have a separate checking account. When you get appointed as the executor or administrator of an estate in Texas, you can apply for a tax identification number from the IRS. This will allow you to open a bank account in the estate's name. When you do that, you can then have it, Joe Smith, comma, executor. This will allow you to get everything pulled together in one place so you know what's happening. Uh, when you're doing that, uh, you pay everything from there. It'll just make everything easier. The accounting for what has gone on really will be much simpler if you write it all out of one checking account. This is not a place where you'd put all of your, kind of commingle it with your own bank account. But from there, it's like paying any other bill. You're writing checks, maybe doing wire transfers, whatever you would normally do. So you know that you've got a good record of how you've paid things off. Well, that's it. That's all the questions we had for this week. We'll be back in 2 weeks with another live stream for questions we've gotten from y'all. Thanks so much for watching. We'll see you then.